Okay.
In 3, 2, 1.
Good evening, good afternoon, everyone. If you're able to see me, you're able to hear me, just give me a yes. So my distance, okay? If you're able to hear me and see me, just give me a yes, so that I know everything is okay and we can proceed. Okay, good. So now, thank you again for joining us today. We have got roughly, there's about 233 of you all online. We have got 400 plus registration for today, so I believe some of them could be delayed. But nevertheless, let us start, and so that we can finish on time. So today we will be speaking on Employment Act Amendment 1955. We may not touch on Sarawak Labour Ordinance and Sabah Labour Ordinance because I think we had another webinar before, and we will have it again next time. So today's focus is very much on Employment Act 1955. In Bahasa we say sudah cerita lapuk because this is something that's happened 3 years ago. But nevertheless, I'm sure we can learn something new from, when we discuss, there'll be a lot of, questions that you guys may ask, or there could be new, scenarios, etc. I'll be also sharing quite a bit of tips and solutions and whatnot, etc. So for the next 2 hours or so, it is now 3:05. For the next 2 hours, I'll be sharing. Part 1 would be very much on the Employment Act Amendment. I have also slotted in a few other additional information, such as wages and a few others, which I think is quite important to connect to the amendment. A bit on flexi work arrangement and a few other things. So part 1 would be very much on Employment Act. And then part 2, I will be sharing a few, maybe not all because of time factor, but I'll be sharing a few strategies that might be very useful to you. Some of you all may have heard before. I've shared couple in the other webinars. I'll share it again. Some of these strategies can resolve your headache that you have, save a lot of time and whatnot. So we'll see how, if you have enough time, I'll cover a few. And then the last part, I will go into the Q&A. So typically this session may take about 2 hours, but if there's a lot of question answer, we can drag a little bit more, so that we can cover as much as we can. So thank you for joining us today. And some of you all probably would know me. I do know some of you all when I saw your names, among the participants today. So just a brief information or brief overview about who I am, who am I. My name is Arul, and I was just like all of you all once upon a time, working, in HR, having served in recruitment, in business partner, in IR, in operations, HR projects, etc. A little bit on, the L&D side. So that is what I've done over the past, and I was lucky enough to work for 2 organizations with 9,000 employees. So both had 9,000 employees. One was a semiconductor company, one was a glove manufacturer. So having been able to start at the lower level and climb up to a director level or HR GM, so that has given me a lot of experience, exposure, connections, context, strategies, etc. So which is very helpful, for some of you all as you encounter your day-to-day HR issues. So for me personally, no issue is a difficult issue. Issues are there. I mean, like it or not, as HR, we must be prepared to face issues, right? If HR has no issues, it may not be HR, because when dealing with employees, there will be some headache, there will be some complication, there will be some problem. Somebody may not come to work, somebody might be doing something that is against the company policy, and it all flows back to HR, human resources team, to manage it, resolve it, find ways how to educate employees to prevent these issues, and so on and so forth. So it's fun in a way. It can be stressful, but it's fun in a way. So for those of you all, if you ever need to reach me, you can see my email address and my phone number. So the slides that you're seeing today, we will share this in our Facebook group, after the call, after the session today. So you can download these slides in the Facebook community later, probably after 5:30 or so. So don't worry about it, you'll get the slides. Now, before I begin, a couple of things that I wanted to just share with you all. on July, okay, the date is missing here. On July, we will be having the HR Career Day. So this is something new. We are doing it for the very first time. So for those companies, particularly in Klang Valley, if you are hiring, any HR roles, only HR roles, for example, whether it's a recruiter, whether it's a payroll, etc. If you are hiring for HR, and you want experienced candidate, so what you need to do, what you could do is join us on the HR Career Day. You got to let us know now what are the positions you're hiring. Only HR roles and not freshies. So we are not. This session is not for fresh graduates. These are for experienced HR professionals. So some of you all, if you are currently in between a job or you've taken a career break and you want to go back to employment, you might also be able. You can also attend this HR Career Day. So roughly, we are looking at about 20 to 25 companies hiring about 30 to 50 roles. So it's a day you can come if you're looking for a job. You can come, you can see almost about 20 employers, provided they are offering the job that you are looking at. You can, assuming, some jobs are relevant to you, you might be able to, meet up and interview 5, 6, 8, or even more companies. We limit to 10 at the max. So you can see these companies and you might even walk away with a job. So when we had similar event for fresh graduates, quite a number of them got a job in that single day. So for those of you all, if you are looking for a job, you have got minimum 1 year work experience as HR, you can walk in, no charges, it's free for you. You can just walk in and what do you call this? Drop your CV and so on. So we will be having a webinar on HR planning and interview prep webinar. This will be on July 3rd. So July 3rd, yeah, I mean, sorry, I don't have the details right now with me, but write it down. For those of you all, if you are looking at, attending this day, it is important that you join the July 3rd webinar. It's free. And this webinar, the purpose is, number one, to guide you to prepare for the career day, how to prepare yourself, how do you answer the interviewer, your resume. So we'll be sharing a resume template as well. And how do you reposition yourself, to apply for, these roles. How do you look at long-term strategies and so on. So for candidates, you can walk in on the event day, which is on 6th of July. But again, we will filter you. If you have got 1 year experience, you can come in for the interview. If you don't have 1 year experience, then of course, we will not allow you in. We will not allow you in because the companies that is coming, they are looking for experienced HR candidates, no freshies. So for you all walk in, for companies, if you have a HR role and you've been trying to fill this role, you're not able to fill. So just imagine in a single day, you have got, 15, 20 candidates to interview. So in fact, I would say in one single day, you can complete your hiring, right? If you've got 2 HR roles, you might be able to complete. So, it takes away that burden from you. So for companies, it is also free for you. So if you are participating, you got to sign up. You need to give us a job description and whatnot. So it's a full day event. We start about 8:30. We finish at about 4 or 5. Breakfast and lunch is provided for companies only, not for candidates, but for companies. So if you're interested, sign up, and our team will will get in touch with you with the details and so on. And like I said, you will be able to complete your hiring, on that very same day. So that is going to happen on the webinar for candidates is on 3rd of July, and the event, the HR Career Day, is on the 6th of July. And also, what we are having is we are having our HR Malaysia HR Tech and Innovation Conference and Expo. I think some of you all may have joined us last year. So it is going to happen again on 22nd and 23rd September, which is Tuesday and Wednesday. It's going to happen in Nexus, the same venue that we had last year. So last year we had about 1,007 delegates, HR practitioners, visitors, employers. So this year it's a 2-day event compared to last year was 1 day. It's 2-day event. We provide morning break and afternoon break. We don't provide lunch because it's free event. It's very costly to provide lunch, but you can always go down to the cafe. But morning break and afternoon break is provided. So if you want to look at what are the latest HR tech and what are the latest HR tools, for example, if you're looking at, upgrading a payroll tool, right? There are many companies who, many HRMS or HRIS providers, payroll tool providers will be there. So you can come and in a single day, you can visit, check out their demo, check out their tools, talk to them, etc. Or if you're looking into implementing talent acquisition, certain tools, For example, you want to look at candidate assessment. So these are the kind of tools that is being showcased there. And as usual, we will have a lot of local and international speakers. This time, we probably have more international speakers compared to local speakers. So you have a chance to listen to them. Some of them are successful HR guys. Some of them are successful entrepreneurs in this area, leaders and whatnot. So good to come and listen. Now, there is also another conference happening at the same time. I call this the Orange Conference. Come to ours, don't go to the Orange Conference. Okay, and last but not least, just a quick one. Now, so Metropolitan College is owned by HR Forum. So we are having diploma in hotel management, business management, human resource management. Now, these are for those employees of yours who don't have a diploma, and they are working. They want to upgrade their career. They want to have a paper qualification. They can pay $399 per month, or if you're willing to sponsor them via HRDF, you can also do so. So if you are interested, share this with them and make a change to their life. This could be a life-changing moment for some of them. So the website that you can visit is metro.edu.my. So go and check it out and share this with your employees, those without a diploma qualification. Okay, and last but not least, one more. SHRM certification. For those of you all, if you are Bumiputra, this program is funded by Yayasan Peneraju. The next cohort is going to be April. So probably maybe the last cohort for this year. So if you are interested, you've got to be very quick. Sign up is fully paid by Yayasan Peneraju. For those of you all who are not Bumi, this program you can also do via HRDF. Of course, your employer will have to sponsor you. So those of you all, if you're interested, whether it's YP or via HRDF, quickly get in touch with us. Let us know, and our team will be in touch with you. Okay, so let me go on to the session today. Now, before I go into the amendment, I like to always share this one slide reminding us all the time about the importance of compliance, right? Compliance is expensive. Sorry, compliance is cheap. If you don't comply, it's expensive. So sometimes we try to find, shortcuts, certain illegal methods or certain tactics, how to avoid, right? How to avoid paying, how to avoid, how to reduce costs, etc. So it is always better to follow the rule, because when we follow the rule, it is cheaper than not following the rule. There are many companies out there, right? They were once upon a time big companies, giants, and because of non-compliance, right? They, either it's a governance issue, compliance issue, or they fake their accounts and whatnot, etc. And ethics issue, integrity issue, and the company has gone, disappeared. There are many giants, right? So we as HR professional, when the company hired us, the company wants us to help them to grow the business, right? Now, let me tell you this. This is my own personal experience as well. We can be successful as an individual. We can be successful as an employer, even if we follow the rules. We don't have to find illegal ways, to get things done. Follow the rules, maybe a bit painful, right? But it makes you better, bigger, stronger, and whatnot. So compliance is cheaper, non-compliance is expensive. Now, let me give you one important thing. Now, this will be very important, so I hope you guys, listen. Some of your company would pay contractual bonus, or you may pay performance bonus. Everybody gets the same figure. Everybody gets the same sum. So if the company has a 1-month contractual bonus, everybody gets it. Or the company may not have 1-month contractual bonus, but you are giving performance-based bonus, right? Company achieves the financial, revenue targets or profit targets. Everybody gets the same sum. Now, that is bonus, not part of ORP, not wages. But if the bonus is paid based on individual performance, for example, A may get 1 month because his performance is A. And then you got another employee, because her performance is a B, she may get 0.75. And then there's another guy, right? Let's say, employee number C or employee C, his performance is even not so good. That means lower rating. He may get 0.5 month bonus. So every employee, their bonus amount is different. So if your bonus follows this method, that means it follows employees' performance achievement, etc. What is going to happen is that is wages. It has got to be included in the ORP for the month that you pay out. So if you pay this bonus, performance-based bonus, different employee get different amount in December. So, and that employee entitled to overtime. So that month, when you compute ORP, you also need to include this bonus into the calculation of ORP. So if you are doing it, please get this checked, right? Speak to Labor Department, get their guidance, and if you are in non-compliant, please get it rectified, right? So this is one example of following the rule and not finding ways how not to do it. Some of you all may not know it. That's fine, right? Maybe you are not aware, and first time you're hearing it. So now that you have heard, please write it down, get it checked. If you are giving non-contractual bonus, that means different employee gets a different sum. Okay, so before I go into amendment, it is very important to always know how does the law come into existence. So, those of you all, if you attended the master class, I always reminded you, do not memorize the law. Do not memorize, okay, the law says this, you memorize it. Now, instead of memorizing, which is difficult to do, instead of memorizing it, if you can understand the intent of the law, what does the law tell us, right? What is the purpose of this, right? Why does the law tell us that we got to do it this way and not that way, right? Why is this a must? If you can understand the intent of the law, then the task to understand, to read, to know becomes much more easier, right? So I will explain a little bit on why I said this. So now there are three ways, three cara how law come into existence. Bagaimanakah undang-undang perburuhan, like this law, employment law, how does it wujud? How does it come into existence? First and foremost is Act of Parliament. Any laws that goes to Parliament, Parliament debates the law, Parliament, Dewan Rakyat approves it, then goes to Dewan Negara, then the king has got to, get a royal consent, and then the minister in charge of that particular law will then decide when to enforce it, right? It goes through this process. So Employment Act, the Labour Ordinance of Sabah Sarawak, Industrial Relations Act, Trade Unions Act, Minimum Retirement Age Act, or any other act goes to the Parliament. Parliament has got to debate and approve it, and then it goes through these layers of approval, and then it becomes, then we enforce it. So it's easy. So if I were to ask all of you all this, guys, ladies and gentlemen, what is the minimum annual leave? You'll say 8 days. Open the Employment Act, 8 days. How many days is a public holiday? Easy, 11 days minimum. How many days sick leave? Easy, right? So why? Because the Employment Act provides for all these benefits. But now if I would ask you this, if I were to terminate an employee, right? If you were to retrench, business not doing well, the company wants to downsize, you need to let go some staffs, or maybe the business closes entirely. So now you need to retrench every employee. Those employees who are earning below 4,000, right? Or those who are manual workers or supervisors of manual laborers, etc. This group, you will have to pay them termination benefit, right? For those of you all, if you are human resources, you are a HR clerk or HR admin, HR exec, HR manager, HR senior manager, etc., or even finance, if you're listening today, if you're earning above 4,000, the termination provision doesn't apply to you. But the other group, those earning below 4, or those lorry drivers, those employees, if you terminate them, you got to pay termination benefit, right? It is provided for in Employment Act. But what is the amount? I'm quite sure you all will tell me now, okay, minimum 10 days if you're less than 2 years, minimum 15 days if you're more than 2 years, right, to 5 years, and then 20 days if you're more than 5 years. Now, you'll say this, but where can I find this? Where will you find this? Employment Act? Now, if you go and check Employment Act, you will not find it there. You will find it in the third bubble. You can see on the bubble on the right-hand side, the green bubble, regulations. So the minister, is empowered to create regulations. So we look at number 2, the employment in bracket termination layoff regulations, layoff benefits regulation 1980. In these regulations, you will find the 10 days, the 15 days, the 20 days, right? So not exactly an Employment Act. But is this piece of regulation a separate regulation? No, it arises from the Employment Act. So it is important that all of y'all, right? It's important that all of y'all please get a copy of this book, right? You can purchase this online, or you can go to Popular. You'll be able to find this book. So this book has a compilation of all the Employment Act and all the regulations. It's quite complete for Peninsular Malaysia. only for Peninsular Malaysia. So I would encourage each and every one of you all, it costs about 30 ringgit or so. So get one copy, keep it. So anytime you can refer to it. Those of you all, if you're attending our masterclass, you'll get a copy of this for free as well. So now these are the regulations. I will be giving out 2 books later. So during the Q&A, we'll be giving out 2 books of the ordinance, right? Or the ordinance. So, the Employment Act. So those of you all, if you want to win the 2 books, please stay until the end. During Q&A, I'll be asking 1-2 questions. The first one to answer, you'll get a copy of this book, 2 of you all. Okay, so now the termination layoff regulations, the green bubble is where you can find the 10 days, 15 days, 20 days. Now, if I were to ask you this, what is the maximum overtime that you can require an employee to work? Now, instantly, many of you all would say 104. So, but where can I find this 104? If I'm your superior, I would say, you know what? Tell me, where can I find it? Right? So if you look into Employment Act, you may not find it there. So where can you find this? There's another regulations arise from Employment Act. The minister is empowered to decide what is the maximum overtime that an employee can perform, which is 104. Where can you find this? You can find this in the limitation of overtime regulations, 1980. Similarly, Sarawak has their own rules, right? Sabah has their own rules. Some of it are quite similar. If here's 104, it is also 104 in Sabah and Sarawak. So you need to get yourself familiarized. Now, there's another one that I believe many of you all may not be aware of. Employment Regulations 1957, right? Now, if a female employee becomes pregnant, and what do you do if they become pregnant? You got to pay them, they become pregnant, they deliver a child, they go through confinement, you got to pay them maternity allowance. Am I right? Now, good. So when they pay maternity allowance, right, as far as the law is concerned, if they go on maternity for 98 days, you got to pay them the allowance, the maternity allowance, which is the equal sum of their wages as allowance. Now, so they go. Now, is that enough? By you paying the allowance, you have done your job. If Labour Department were to come and knock on your door and they check everything's okay, answer is no. Yes, you got to pay, but the Employment Regulations 1957 also requires you to fill up a maternity register. It's a 2-page document, right? You got to fill up the maternity register, not to submit to Labour Department. You fill up the register and you keep in the office. So if one fine day, the Labour Department, wants to come and audit you and look into all your documentations and whether you're compliant, one of the documents they could ask you, please show me the maternity register. So you got to show it to them. If you don't show, then the penalty can be, a fine not exceeding 50,000 ringgit. So you got to maintain a maternity register, not just payment. We update our payroll system. Okay, maternity allowance, maternity leave, pay 98 days, right? That is payment. But where is the register? Right? You got to maintain a hard copy register. It's not a soft copy, it's a hard copy register. Fill up and keep, not to be submitted to Labour Office. Fill up and keep. So where can you find this? Employment Regulations 1957. So for those of you all, if you're hearing this for the very first time, write it down and get it checked, right? See whether you're in compliance. Or, for example, where should you keep your personal files? Your HQ happen to be in, let's say, Penang, and you got a branch in Ipoh. You hire somebody to be based in Ipoh, but you keep the personal file, the employee's file records, employee records in Penang. That is again wrong. Employees' records has got to be kept where they are attached to. If their place of work is in Ipoh, it's got to be in Ipoh. However, you can always apply for exemption. There's a permit to apply, exemption to keep the employee records at the HQ, right? So these are regulations that you got to observe. Now, the other one, which some of you all may be, you may say, oh, really? Pay slips, right? Most of your pay slips are in soft copy, but Employment Regulations 1957 says that pay slips has got to be in hard copy. Otherwise, fine. 50,000 max. So what do? Maybe all your employees are, having access to emails, or you have a mobile app and whatnot, and everybody use. So apply for exemption. I can't recall, was it Borang L? I can't recall. Menyimpan daftar pekerja dalam bentuk lain. Right? Fill it up, get it approved, and you're okay. Then use your soft copy payslip. So these are the regulations that you need to take note of. So as HR practitioner, your job is to ensure that the company is compliant. Remember I said compliance is, etc. So your job as HR practitioner, because your boss, the CEO, will not know all this. The reason I hire you, I'm the CEO, I hire you for you to make sure that you get all this thing done. Please ensure that the company is not, company complies with the regulations, the laws, right? That's your job. So you got to know this. So if you don't know, and for some reason it becomes an issue, and and you're audited and you don't have it, and the labor department finds you, now I'm sure your boss is going to be very angry with you, right? So please get it checked. So it's very important that you as HR practitioner, the Employment Act, the Minimum Retirement Age Act, and what I did not put here is Employment of Child and Young Persons is another act, right? Download all this, keep a copy in your hard drive, print out, read it at times, and so on, and all the regulations. So the best thing you can do, get that yellow book that I just showed you by ILBS, go and purchase one, or you come to a masterclass, we'll give you one copy, keep it with you. So you can always refer, highlight, and so on and so forth. Now, the first bubble and the third bubble is easy. You read, you'll find it. But you got to know how to interpret, right? Later part, when I talk about sick leave, there's something in sick leave that, again, some of you all may not be aware of. But if you read dengan mata kasar, right? If you read with your general eye, you will not be able to find it. You must know how to read. Firstly is, we must know where to find, right? Where can I find this in the Employment Act? Where can I find it in regulations? You got to read. You got to, firstly, you got to find where is it. Then you got to read it. Then you got to interpret, right? The way you read and the way you interpret may not be the way I read, the way I interpret. So later I got a small exercise. Hang on first, right? So the third bubble, first bubble is easy. But if I were to ask you this, ladies and gentlemen, if I hire somebody on a fixed term contract, 1 year contract, fixed term means 1 year or maybe 6 months, depending on, the duration. So let's say 1 year contract, 1 year, renew. And let's say after 9 years, is this employee a permanent employee, or are they a contractual employee, on a fixed term contract? I'm sure many of you all would say, oh, so many renewal should be permanent, right? Now, is that the right way to say? Not exactly. So in the case of Han Chiang School, right, what has happened? The teachers were hired on a part-time basis, on a fixed-term contract for so many years, and one fine day the school told them, okay, you know what, your contract's over, please go, thank you, bye. But the teachers felt that, why am I not being continued? Because for the last so many years, the company renewed me. I never asked for renewal, the company just gave renewal, right, which many of you all would also do. The renewal has become automatic. I never asked for it. There's no discussion. I got a contract. I got a new contract, right? So now what we have learned from Han Chiang School is that permanent job, permanent contract. Temporary job, maybe 1 year job, temporary contract or fixed term contract, right? So what we do at times, permanent job, the job is permanent, the task is permanent, but we hire people on contract, 1 year, and for some reason, maybe we don't like them anymore, we remove them and get somebody new. Now, this is what the Han Chiang School case tells about. Similarly, when you retrench workers, let's say business not doing well, but you're not going to let go everyone. You need some people to stay, but some people you don't want them anymore because that department or that position no more. You want to reduce your workforce. So should you first remove the last in or the first in? For example, somebody came in, somebody was hired 10 years ago, and somebody in the similar job, similar capacity was hired 2 years ago. So who should go first? The one who joined 10 years ago or the one who joined 2 years ago, right? I think some of you in your mind, you say, no, last in, first out, right? Yes, the last in should go out first, right? So the one who joined 2 years ago should go first. The one 10 years, he's safe. Now, your boss is going to ask you, I want to choose, right? I want to cherry pick. I want to choose who to go. Now you say, no, boss cannot, etc. Because why? The law says cannot. The boss is going to ask you, show me the law. And what you're going to do? You're going to find Employment Act. Or you're going to call Labour Office. Encik, I nak tanya mana itu. Or you're going to WhatsApp, come to Facebook group. Where are this? So now, it is important for you to also read case laws. When a case goes to the court, whether it's in industrial court, high court, appeal, or in the past, it's got federal court, as the last resort, as the last appeal. Now, if it goes to the court makes a ruling, that becomes binding on you now, right? So in the retrenchment practices, the court says that you should remove the last in the same job, right? A manager and a technician, they're not in the same capacity. When you have two technicians, both are doing the same job grade, same capacity, who should you remove first? The technician who joined recently, right? That's what the court case says. So that is why it's important to also read case laws. But the court also says this: must you follow last in, first out? You can choose not to follow if you have a good reason not to follow. So let me give you an example. Now, whatever I'm saying, right, you can't find in Employment Act, you can't find in regulations, you can only learn this from case laws. So when you read the case award, whether the case has gone to industrial court or High Court makes a judgment or Court of Appeal, you read it. The court will say, ini boleh, ini tak boleh. Why? So now that becomes a case law. So now, if you have two technicians, technician A, technician B, the first technician joined the company 10 years ago. The other technician joined the company 2 years ago. Both are the same job grade. They do the similar job, same capacity, right? So what is going to happen now? Company is not doing well. The boss, the management says, we only need one technician. We don't need two. We just need one. So HR, can you please carry out a redundancy, retrench one? So now what do? The boss will tell you, okay, look here, I want the younger employee, the one with 2 years experience. I don't want the one with 10 years. So can or cannot? So what the industrial court and the court, or high court and so on says that if you don't want to follow last in, first out, can, but you must justify why. So now, my company, for example, I want to remove the employee, I want to retrench the employee with 10 years experience, but I want to keep the one with 2 years experience. Why? Because we have got machinery. The old machinery we are slowly removing. We have removed a lot of old machinery. So what we have today, majority is the new machinery. Now, the older employee, he finished SPM, worked for so many years, no diploma, nothing. So rank and file. Rank and file means no qualification. They just work and climb, and they reach a level, right? Maybe join as operator, then became a technician. So it's rank and file. This person don't have a diploma. And this person can only repair the old machines. Those machines that is very old, the older one can. But this person cannot repair the new machine. He also cannot read engineering drawing. So his capacity, his ability is limited. But the new employee, the one with 2 years experience, this employee, whether it's a he or a she, this person can repair the new machines. This person also got a diploma in electrical engineering. And this person can also read engineering drawing. They don't just, this person is not only able to repair, but they're able, troubleshoot or whatever, they can also repair, they can handle high level of, repair, because they can read the drawing. And they can also write documentation. So for that reason, I'm removing the older employee, but I'm going to keep the newer employee. Now, with this reason, I'm quite sure based on all the past cases, your case will be accepted. So now, this is why it is important for all of you all to read case laws, right? You have to have the ability to read. Now, if you want to grow in HR, again, I've bypassed the stage already, but if you want to grow, you have to put yourself into a position, into a situation where you are learning and learning and learning. Of course, I have to congratulate all of you all. We have got almost 80,000 members in our Facebook community, plus all our WhatsApp group. If I include all, assuming all are different individuals, we got almost about 90,000 plus. But today, only 400 people are in the call. So maybe the others all sudah terpelajar, but I can tell you many of them are also not. They say busy, etc. But sometimes I always ask this: why do we make excuses for learning? Right? When it comes to learning, oh, cannot, I got meeting today, I'm on annual leave today, etc. This webinar, we shared the date 1-2 months ago. We didn't just share the date today morning. You know the dates 2 months ago. Some of you registered much earlier. So we can make excuses for holiday. Oh, no, I must go holiday. I already bought the ticket, I must go holiday, right? I must stay at home, I must. But when it comes to learning, we have all the excuses in the world. Not good, right? There's a saying by, what's our friend's name? I just can't recall this motivational guy. So he says this, Brian Tracy says this, as a young, professional, fresh graduate, young, or you have not reached the level yet, he says this: come a bit, you got to develop this mentality, come a bit early to work a bit harder, go back a little bit later, right? And so on. You will become much better than the rest, right? So you guys, the 400 of you all today, fantastic. You have pushed yourself to listen, because I'm sure, even if I stop the webinar right now, I'm quite sure you've already learned something, right? Give me a yes or no, right? I'm sure if I stop the webinar right now, you already learned a few things. Maybe not one, maybe a few. Or worst case scenario, you've learned something, right? Something that you never know before, but right not. So now it is important to learn. So I would encourage all of you all, right? If you do not know where to start, how to start, don't worry about it. You are members of the Facebook group. Every time, whether it's me or Haji Hussein or Mr. Ganesh or Rachel or Encik Sulaiman, all, I tell you, there's so many people in the forum, they selflessly share information, documents, case awards, etc. Every time they share something, read. After you read, don't understand, ask question, right? And you keep doing this again and again and again and again and again. One fine day, you will be doing what I'm doing today. You will be sharing with the rest. So please read, right? Many of our HR practices today, it is not in the act per se, not in the regulations. Many of practices today comes from case laws. For example, you hear this during Chinese New Year typically. Can a company force employees to take annual leave? You probably say, no, cannot, right? You probably say cannot. Why? Because, the Ministry of Human Resource, our HR ministry, issued a circular. I think they've done it a couple of times. Annual leave cannot force. But that circular is not a law. When there's a garis panduan, it's not a law, right? It is only a law if it's in Employment Act, regulations, or when the court tells us. So now, in the case of Dunlop Industries, the court, the judge, the late Justice Harun, he said what? Annual leave is for employees' personal reasons, not for companies' convenience. So because it's a case law, now it becomes a law. So you cannot force annual leave. That's why the Ministry of HR issued a circular that you cannot force employee to to use annual leave for company's purpose. Then in another case, Continental Tire, told employees take 2 days annual leave for plant shutdown. The union was not happy, fought the case, and the company had to pay back the 2 days annual leave. So all this, you got to educate your bosses, right? Now, let me give you one small trick. Adli, maybe just share this with me, and you tell me whether yes or no. So my colleague here will let me know whether you type yes or no. Was there a time when your boss, your MD, your CEO asked you, and they don't trust you? Yes or no? Was there a time, when the MD told you that I don't trust what you're saying? Call the labor department, call IR, call labor department, call the lawyer, call this guy, call that guy. Yes or no? Anyone? Got right? Now, do you know why? Because, take it with a pinch of salt. Why? Because you have failed to do the right things the right way. So how to overcome this? I'm sure you see, when you want to become a manager, senior manager, you want to win the boss's trust. If we don't win the boss's trust, we cannot grow. The bosses will only promote people that he can trust. Not just trust, kaki bode, apple polish, no. Trust that if I were to, hire this person, if I were to promote this person, I trust that they will be able to get the job done. So what you can do starting today, it's a very important tip, it's $1 million tip. Whenever you read a case, whenever we discuss something in Facebook, something significant, something, not a small topic, something significant, the case went to the court says that this cannot. Whether your company is, having this issue or not, print out the case, read it, highlight, do a summary, right? You can even put the case into ChatGPT, tell the ChatGPT, can you do a summary for me? See your superior, see your bosses, present it to them. Dear Mr. John, I would like to just share with you, there's a recent case that has gone to the court, and the court has made a ruling, the court has made a decision, and I think it's important for us to know because we are having this similar scenario. So the court says that this cannot. And what I've done, I've also consulted, I've also checked around and got feedback from the others. Of course, I'm not going to tell them my company got this issue, just to get the input. You know what? I spoke to some HR practitioners, some HR gurus out there, etc. and they all gave this input. So I think it's important, for me to bring this up to you so that we could look into ways how we can make some changes to the way we're doing it to be in compliant, right? Just imagine if you keep doing this. I'm not asking you to see your boss every day. He'll be tired to see you every day. No, whenever there's something significant out there, you heard about it, right? Don't just hear and keep in our, in our mind, in our otak. Read it, highlight it, present to your boss. You keep doing this again and again and again over a period of next 6 months, 9 months, 1 year. One day, your boss is going to say, you know what? My employee is very proactive, right? She's able to give me, she updates me what's happening out there, right? She tells me what's happening. She don't just tell me, she also, have ideas, methods, solutions, what we can do. And she is able to implement it, right? That is what you got to do. Some HR, I'm so sorry to say this, we are bellboys, right? Like waiter, waitresses, just take order. Boss said do it. Okay, boss, yes, I do it, right? We are order takers, bellboy. We got to move up the value chain, right? We got to be operating at the next level. Those of you all, if you're really serious about growing, moving up, write this down. Are we operating at the next level, or are we just being busy? Being busy is easy, right? You just do this, do that, check email, clear WhatsApp, do this form, busy. Easy to do, right? So sometimes you say busy is easy. But are you operating at the next level? Are you being strategic, or are you just busy, right? If you want to grow the HR career, you got to be operating at the next level, and you got to be strategic, right? Okay, so this is very much on how the laws come into existence. Now, the reason why I want you to say this, now, I like to joke this. If there's any labor officers, in the call, right, you might find this quite funny. Now, I'm sure you'll tell me this. Hey, I call labor officer A will say A. If I call labor officer B will say B. If I call officer C will give me a different answer. If I call officer D, he'll give me a different answer. Some of y'all, you're very smart. You call labor department in Subang, then you call labor department in Bangi, you call labor department in Klang, just to get, what is that? Yes or no? Do you all do that? Different officers give you different answers? Right? I'm sure some of you all, yes or no? So now the reason why, the problem is you, not the labor officer. I'm not supporting them, but I can tell you the problem is not them. Do you know why? Now, if you call the labor department, right? Just pass me the yellow book. So if you call the labor department, right? Employment Act, right? If you call the labor department and all your questions are within the design of Employment Act or the regulations, if you ask anything within the design, you will get the same answer from officer A, officer B, officer C, until officer Z. You'll get the same answer. But when you ask questions outside the design, you pandai change your working hours, right? You pandai, come morning, break 3 hours. Now, what does the law say about break? Every 5 hours, minimum 3. Every 5 hours, minimum. You go and modify the way you do things, etc., and perandakan your operation, and then you want the answers to suit your needs. It doesn't work that way. You ask officer, you ask the labor officer whether different department, Bangi, Klang, or Subang, or even, Melaka, you call them, you ask them, what is the number of days for maternity allowance? How much should I pay for retrench workers, 10, 15, 20? They all will give you the same answer. Why? Because you're asking within the design. But when you modify the design, you want to have your own practices, and then you're not sure, then you start asking, then different officers will give you different opinion. Are they wrong? I don't think so. Right? So that is the issue here. And then sometimes when you ask questions, we don't ask questions like intelligently. Can, Encik, boleh? Can, cannot? Boleh ke tak boleh? Like school leavers want a quick answer, yes, no. That is not the way to ask. You got to call them and explain to them saying that, okay, I would like to ask this. According to section 25A says this, etc. So that's how you should do. Okay. Now, so please join HR Forum. If you don't have please get all your members to join us. I can tell you, not that because I'm attached to this organization, But this is the best thing that has happened in Malaysia, I would say in history. Nowhere else you can get free webinars like this, right? No other brands out there, right, that gives you all this, right? Some of you will be saying, oh, no, you know what? I tell you, let me share a joke. Some of you all, they call us up, I got this problem, how to do this. Then we find out they happen to be paying membership fee to another association, right? Or other association. Why not you call them and ask? Oh no, we call them, they don't answer our calls, right? So they come. So I can tell you, this is the best platform, the best thing that's happened to HR folks in Malaysia. During my early days, we never had all this, right? Free webinars like this. So make the best use of it. Get all your HR practitioners in, right? Get everyone in and make them learn. Download the documents. We share documents. We share samples. Now, for those of you all coming from Johor and Negeri Sembilan, the State Assembly for Negeri Johor dissolved the Dewan Undangan Negeri. So what have you done? Have you sent a first memo out to tell employees that if the government declares a holiday, we will work as usual or whatever, etc.? Now, if you've not done it, why? We have already shared the sample memo. So a proactive HR would have quickly speak to the boss. Boss, you know what? The government has declared, dissolved the State Assembly. We have to inform, because you know why? Chances are the government would declare a public holiday. So we should tell our employees now, whether you observe, then tell them. If you don't observe, it's easy. Tell the employee, if the government declares a public holiday, we may work as usual on that day. And we'll give you a replacement holiday another day. So when the government suddenly declares a holiday, you are ready. Otherwise, your weekend, you'll become telephone operator. Your employees will be calling you. So Monday kerja ke tak kerja, right? So you got to be operating at the next level of things. So get all your employees, get all your HR practitioners to join. Okay, so minimum wage, right? It's covered a little bit here and there. So before I go into the amendment, so minimum wage. So there could be the government is talking about amending the minimum wage. What exactly is minimum wage? Gaji pokok. No commissions, no allowances. Purely gaji pokok, right? That is called minimum wage. So today the minimum wage is 1,007. You may have seen this table. Those who are paid monthly, 1,007. Those who are paid daily, that means some of them you may hire them on a daily basis. Okay, you come to work 6 days a week. Every day I pay you 65.38. Total is still 1,007. Right? How to derive this? You can see the formula at the bottom. Or you may employ them on 4 days work week. In every week, you work 4 days. Every day I pay you 98.08 minimum. That is minimum wage, right? You calculate, total is still 1,007. Or you may hire them on hourly rate, right? Part-timers, for example. So I've got a strategy on part-timers. I'll share with you at the later part of the webinar today. Part-timers is $8.72, right? How do we derive? The formulas there. So what is part-timers? Those people who come maybe 3 hours per day, right? And so on and so forth. Also, the minimum wage order says that you can also hire an employee on piece rate or tonnage or based on task, trip, commission. The cement truck drivers, the guys who drive the cement truck, they are paid on commission or maybe trip or tonnage. You go and deliver one cement a truck with X amount of ton, you come back, I pay you 200 ringgit. In a month, the total trip that they perform during normal hours of work must pay them 1,700. That's minimum wage. Or, okay, I'm going to hire, another example is, now your job is to produce this piece, assemble it. Every one product, every one piece, I pay you 1 ringgit. So as a company, I must give you the opportunity to assemble 1,700 pieces of this. You assemble during normal hours, I pay you 1,007 in total. You produce 1,007, I pay 1,007, that's minimum wage, right? So get yourself familiarized with this. Now, this is the amendment. So what has happened in the past, those employees who are below 2,000 ringgit, right? If they're not manual workers, they're below 2,000 ringgit. They're not supervisors, below 2,000 ringgit. Or they don't drive, mechanical vehicles, etc. They're below 2,000 ringgit. This group is covered in Employment Act. So if you are in HR, finance, or some executive level, earning above 2,000, before the amendment, you are not part of employment. You're not covered. Employment doesn't cover you. It's not meant for you. But what has happened when the act was amended? Everybody now, as long as you have a contract of service, you are covered under Employment Act. That means the CEO of Petronas, if he is given a contract of service, he is an employee, he's covered under the Act. Your MD, if he's hired, he's got an employment contract, or in other words, contract of service, he is covered. Even the foreign expatriate from, let's say, Singapore or America or Philippines, right? They are covered. Or you hire the employee, the blue collar worker from Bangladesh or or Myanmar or Indonesia, they are covered. So any employee, irrespective of their service salary, as long as they got contract of service, they're covered. So it means all of y'all, if you are an employee, you are covered. Now, so everything under the Act, everything you read, all sick leave, public holiday, everything covers everybody, right? Everybody, except the 6 items that you can see on the right-hand side. It does not apply to certain people, right? So everything applies, but the 6 items that you see on the right, if they work on a paid rest day, they got to be paid ×1 ORP ×2 hourly rate pay. If they work on a public holiday, the ×2 ×3, I'm sure you know these labels, right? ×2 ×3. So all these 6 items here, or these 6 subsections, do not apply to certain category. So let me explain in detail. So this, as HR, one of the very important traits that you must have is the ability to present your information in a way that is easy for people to understand. It also makes it easy for you to explain. So just imagine, if I were to explain to you this particular exclusion, right? The first schedule, I just, okay, those people, you will not be able to understand, right? You will get confused. And while I'm presenting, I will get myself confused, right? So the better way is always to put into a format, into a manner or an illustration easy to understand. So please pay attention, because this is one of the most important aspects of the amendment. So now, those who are doing manual labor, for example, your operator, your cleaner, manual labor are those employees who are doing manual tasks more than 50% of their time. So if the person is doing operator's job, cleaning job the whole day, they are manual labor, right? Or those people who are maintaining, right? They operate or they maintain any mechanically propelled vehicle, lorries and whatnot. So they are also in this category. Or if there's somebody supervising or overseeing another employee who's a manual labor. So you may have in manufacturing, in some service sector, you may have a supervisor looking after some, employees in manual labor. So they are also in this category. So those people in this category, it does not matter whether their salary is above 4 or below 4. So if I ask you a question, who do not get OT? Some of you will instantly tell me above 4K, no OT. That is not the right answer. Because why? Those who are manual labor, those who are operating or maintaining any vehicle, mechanically propelled vehicle, or if they're supervising or they oversee another employee in manual labor, this group, it does not matter what salary, whether below 4 or above 4, you got to pay them OT. You got to pay them rest day pay if they work on a rest day. If they work on public holiday, you got to pay them the 2 days or 2 times ORP, 3 times HRP. If you terminate them, you got to pay termination benefit. So now, if you have a lorry driver, someone drives lorry, he drives the lorry the whole day, and he's earning 8,000 ringgit. Do you need to pay him OT? Yun, any answer? If the person is a lorry driver earning 8,000 ringgit, do you need to pay them OT? Anyone? Yes or no? Quick, you got to tell me so I know, at least I know whether you're, okay, yes, you got to pay. Why? Because the lorry driver will fall into the category of manual labor. He's maintaining or operating the vehicle. It does not matter what his salary is. If you have a supervisor who is managing, overseeing, supervising another manual labor, let's say in a factory, right? In manufacturing, the supervisor manages the operators. So he is supervising manual labor. and your supervisor's salary is 10,000 ringgit basic, do you need to pay him OT if he works on a rest day? Do you need to pay him, what do you call this, pay for a public holiday? Yes or no? Yes. Why? Because for the category on the left, it does not matter what salary. Now, then what about the other employees? Those who are not manual labor, they are other employees. Those who are not operating mechanically propelled vehicle, they are other employees. Those who are not supervising another manual labor, they are other employees. Who are the others? HR exec, finance exec, HR manager, sales exec, operation director, quality director, finance manager, accounts manager, CEO, right? Quality assurance executive, or R&D engineer. Now, all of them are other employees, right? If all of you are from HR, finance, operations, admin, right? You are under the category of other employees. So for this group, if you're earning up to 4, then you are in the green box. If you're earning more than 4, you are in the red box. So for those of you all, if you're in the red box, if you work on a public holiday, I can give you replacement leave. But those people in the green box, right? This is a very favorite question. Every time public holiday, this question will crop up. Can I give replacement leave? You can give replacement leave for those people in the red box. Those in the green box, if they work, of course, if they enjoy the holiday, no issues, go and enjoy a holiday, public holiday. But those in the green box, if they work on a public holiday, you got to pay them 2 times ORP if they work the normal hours. 2 times ORP. You cannot replace. You got to pay them. If you want to give replacement leave as something extra, no problem. But you got to pay them. So remember this. Those in the green box, if they work on a public holiday, they work on a rest day, or if they do overtime, they got to be paid. You cannot contra with replacement leave. You got to pay them. But those people in the red box, discuss with the employee, maybe agree on some payment or maybe replacement leave, like you all. Let's say now, if I want you to work on a Saturday, it's your off day, or Sunday. Now you agree to work, maybe there's a event, I want you to go and be there, and you all say, okay. So now you're in the red box. So for you, I can say, you know what, John, can you come and support our event? We got an important event in KLCC. Can you come and support? You say, okay. Now I'll give you replacement leave. So am I wrong? I'm not wrong. Because the red box, talk to them. The law do not state or do not dictate or mandate that you must pay John. But those in the green box, if you ask them to work during public holiday, you got to pay them, right? So now, today there was it's not an interesting question, but it has, these are common questions. If the company wants an employee to come and do some training, learn on a weekend, on an off day, right? Maybe team building off day, and they happen to be in the green box, do I need to pay them, Sunday pay or public holiday pay? Yes or no? Right? Those people in the green box, if I want them to come and join team building, or there's some training on their off day, do I need to pay them OT for off day? Those people in the green box. Yes or no? You guys are very slow, lah. Say again? Okay. So what is it? Yes. Now, maybe before I say yes or no, if you make it mandatory, then you got to pay. If you make it optional, you can choose not to pay. Because why? You can say, you want to come, you come, right? So you don't want to come, is no problem. But if you make it mandatory, you tell them, you must come. If you don't come, you'll get a warning letter. Then that can be considered as part of work. So you got to pay, right? So this is the green box, red box. So I wish I can give you some trivia, but we don't have much time, so let me move on. Now, so you already know that the 4,000. How do we decide what is the 4,000? Is it only the basic salary, or is it some allowances? So now if you go to first schedule and you read the box on the right hand side, to determine what is the 4,000, you follow the definition of wages in section 2, which is on the left hand side, but you don't include commission, don't include subsistence allowance, don't include overtime. So when I combine this, so what it says, in order to determine what is the 4,000, you only take into account basic wages and all other payments in cash for work done. So basic salary, incentives, right? Maybe you give a shift allowance, meal allowance, right? So all these are considered payments in cash. So you take all these things in, and if it's above 4 or below 4, then you can decide whether they are in the red box or green box. Now remember this, you only need to do calculation for those people in the other category. For those people in the green box, don't waste your time calculating, because whether their salary is below 4 or above 4, they covered, OT has got to be paid. But for the other employees, the green and red, are they above 4, below 4? Then you need to use this to determine. So you got to take their wages and all other payments in cash that you pay, then once you come to a figure, you calculate, oh, it's 3,008, he's in the red box. If you calculate, it is 4,002, he's in the green box, right? So this is on the wages, right? So this is an example. I will share these slides with you. You can read it, you will understand this. And if you don't know, please ask in Facebook. Okay, another amendment that has been made is, what is the calculation for wages for incomplete month? So if, let's say, for example, the employee halfway joined. So today is what? Today is the 10th, is it? So today they join. How do I pay the salary? The month is not complete. Or if they resign today is the last day, how do I calculate? So this is the formula that is given by Employment Act to complete for, when the month is not complete. Or if they've taken unpaid leave, you also use this formula. The monthly salary or the wages divided by number of days in a month. So for example, in May, if you are paying monthly salary, May is 31, so 2,000 ringgit divide 31 times 15 days. Then you get output. So this is the formula. Now, for those of you all, if you are involved in the manpower business, you are supplying manpower to another company. So this is for you are basically a contractor for labor. So if you are a contractor for labor and you are supplying employees, manpower to another company, under Section 33A, you are required to register with the DG, that means the Labor Department, within 14 days before you supply this manpower to the company. So if you fail to do so, and you fail to fulfill certain conditions at the bottom, if you fail to do so, then a maximum fine of not more than 50,000 ringgit. So these are for those people who are supplying manpower. But if you are receiving manpower from another company, this doesn't apply to you, not your concern, right? But it's always good to ensure that your suppliers, right, your contractors follows the rule. Because if something goes wrong with them, you are also affected. So remind your manpower supplier, ask them, hey, have you registered with Labor Department? Because Section 33A says that if you are supplying manpower to me, you're supposed to register. Have you registered? So what you don't want, right? I'm just telling worst case scenario. What you don't want, let's say there's a complaint and you have got the Labor Department come to your office, ambush your office, and then people take photo and, so you wouldn't want that to be seen, right? Doesn't look good on your brand. So please ensure that your manpower supplier, right, follows this, right? That is what I call as a good, a client who follows the rule, right? Doesn't affect you. You can choose not to do it, but I wouldn't want my supplier to be not following the rules. Pregnant maternity, I think this is understood. It is now 98 days, right? And what it says here, if an employee wants to come back to work, now she may not get maternity allowance. What does EA says? What does Sarawak Labour Ordinance says? What does Sabah Labour Ordinance says? Maternity allowance is only for the first 5 living child. So let's say now a female employee delivers a child number 5, she will get the allowance for 98 days. But if this female employee delivers a child number 6, the first 5 child is still alive, she won't get. So some will be getting allowance, some will be not getting allowance. So why do I call it allowance? Does that mean that a female employee will get salary and allowance at the same time? No, because wages is for work done. You work, you get salary. But they're not working, so no salary. So the law says you give an allowance to them of the equal value. So some of you all may call it paid maternity, unpaid maternity. Okay, don't worry about labels. As long as you pay the same value, same amount, you're safe. So now, whether the employee is receiving a maternity allowance or not, she can come back to work earlier. So how? There's two conditions. Number one, the doctor must say she's fit. Number two, the company must say okay. So if these two conditions are met, she can come back. So we have a form that can help you to administer this. Go to the forum, search for a form which is called early return to work from pregnancy or something like that. Download the form. It'll make your life easy when you have this form. So any employer will come back, you tell them, you take this form, you go and see your doctor, my doctor, whose doctor, you decide. So you must have a policy as well. If an employee wants to come back, should they go to your doctor, you pay for it, or their doctor, they pay for it, right? Have all this in your policy so that when it happens, everything is easy. That is why I asked you a question just now. Are you busy or are you operating at the next level? Majority would be busy, right? You react when issues happen. But some of you all could be operating at the next level. Everything is clear, everything is structured. If something happens, the system takes care of it. Now, that is what I call as operating at the next level. So that is on maternity. And Section 41A, I just make it a little bit more simple. If the female employee is pregnant, right, or she becomes ill, sick, because of the pregnancy, arising out of the pregnancy, the company cannot terminate her, except, kecuali, right? If she's pregnant or she becomes sick because of pregnancy, you cannot terminate the female employee, except there's a breach and you terminate them. Major breach, theft, right? Stealing, forgery of document, major, you terminate them. Misconduct, right? Misconduct second, right? Misconduct and closure of employee's business. Your business closed down, right? So if any of these three scenarios happen, you can terminate them, but otherwise cannot. There's one case that went to the industrial court. Some of you all may know about this. The company didn't close, but one business unit, one small department or one department closed. So in that department, there was a pregnant lady. So the company retrenched her. She was not happy. She filed a case. And what the industrial court says, I think it's industrial court, what the industrial court says, Section 41A says that you can only terminate a female employee if the closure of the business. So 41A1C says that closure of business. But in this case, the business did not close. The department closed, not the business. Here it says that the whole company must close. So company lost the case. So remember this, you got to know how to read, how to interpret. Closure of employer's business, not division, not department, not a function, right? So closure of employee's business. Work hours, I think is quite straightforward. 48 hours, now it's 45. Now, can you look at, on the right-hand side amendment, the third box? The minister may make regulations for matters relating to night work or working at night. So remember the third bubble, the green bubble just now, regulations. Now, these are the provisions that gives the minister to create regulations. Similarly, right at the bottom, the minister may make regulations on entitlement, allowance during shift work. So that means one fine day, if the minister sees there's a need, our HR minister says that, you know what, I think we could do a regulation. So employees working at night must be given minimum shift allowance of 5 ringgit, for example. So the minister can create a regulation called Shift Work Regulation 2027 next year, for example, right? And in the regulation says that any employees working a night shift more than 8 hours must be paid X amount of money, right? So now there's a new regulation. So is it a separate document? No. It comes from Employment Act. It arises from here because there's a provision that allows the minister to create. So it's not a separate thing altogether. So this is where the green bubble that I spoke of just now arises from. Sick leave, sick leave and hospitalization leave. Previously, 14 days was part of 60, total is 60. Now, mereka sudah berpisah. Sick leave is sick leave, hospitalization is hospitalization leave. What is sick leave? You will say sick leave means if you're sick, etc., take MC. For some employees, ini adalah cuti tahunan tambahan, additional annual leave. I don't want to come to work today, apply MC, right? So you have to have a mechanism how to prevent people from abusing your MC. So we have shared a very comprehensive and airtight medical policy in the forum. If you apply what is in that policy that we shared, a sample policy, the number of cases of people abusing your MC will be less. So you want to know more, go and download the policy. I'm not able to share it today. Go and download. Those of you all who attended the masterclass, we have gone through all this, what to do, how to do, etc. We've covered all this. I hope you've already implemented them. So there is a method how to prevent abusers, right? Not just method, there are methods, a few methods, how to prevent people from abusing MC. It's very costly. Suddenly, yesterday the person was perfectly well, today on MC, tomorrow they come back perfectly well. So sometimes we don't know what sickness they have. And now there's a news circulating, right? If you go and see Google, news, I think Astro Awani, I don't know when was it, but quite recently. Was it last year? There were 4 million MCs that people buy MCs, 4 million MCs, right? The report says. What I really do not know, but you might want to go in. So it happens. There are cases where people buy, they get MCs. How they get, I don't know. But they're getting MCs. But they are not unwell. That means mereka sehat, tapi dapat MC. How? So you as an employer, you must also have a mechanism to manage this, right? So download the sample policy that we shared in the forum. You read it, you'll get some ideas from there, right? So those of you all who attended masterclass, you have learned it. I hope by now you've already implemented the policy, work out the mechanism, launch your medical process management, the surveillance form that we have shared. I hope you all have done it. Okay, so that is on that. I just want to cover one aspect, but this is not the amendment, but something that you guys need to know. Now, if an employee come and present to you saying that, okay, ini saya punya cuti sakit, my sick leave, and this is hospitalization leave, right? But you look at the MC, nothing there says hospitalization. So then you argue with them. Then you call here, call there, call the whole wide world. Thank God thank God you're not calling Donald Trump, right? You call here, call there, ask, should it be hospital, etc. Now, if you read this provision under sick leave, it says that provided that if an employee is certified by such registered medical practitioner that they are ill enough but not hospitalized, but deemed to be hospitalized, certified. So you got to, like I said, please read the policy. Now, if you guys don't read, too bad, right? The policy is there. It took us some time to draft the policy, get it vetted, etc., proofread it. If you guys don't do it, I don't know what to say. So you got to train your employees. Look here, John, Sarah, Sandra, Ali, Amin, etc. Now, if you give us an MC and you want it to be considered hospitalization leave, firstly, you must have, you must be unwell, hospital. Get the doctor to certify, either chop, write, whatever, that it is hospitalization. Otherwise, it is MC. So do not take the burden on your head. You got to throw it back to the employees, not you. No point you go and call here, call there, call this fella, that fella, call everybody. No need. You tell the employee, as far as Section 60F is concerned, it must be certified by the doctor that you are ill enough to be hospitalized, but you're not hospitalized. Therefore, you're qualified, you're entitled for hospitalization leave. Not for you to figure out, not for you to do your PhD research. Your research, should it be HL or SL? Not for you. You tell the employee, if ever, guys, you are going to be hospitalized, you're going to be discharged, and so on, the MC must have the certification or certified by doctor that you're ill enough to be hospitalized. So HL. If not, we will only consider that you are on sick leave. So not your burden, it's back to them. So now this is how you interpret. It is not amendment, but I just want to bring this up so that you know. Now, if you read Section 60F, any one of you all, if you have the Employment Act next to you, open up Section 60F1. It says this: an employee shall be examined at the expense of the employer by a registered medical practitioner duly appointed by you. So it says that if you want them to go to this clinic, you got to pay. You appoint them, you pay. So medication, you don't have to pay. You only have to pay for consultation, examination. So if you ask the clinic to split the MC, to itemize, there will be cost of consultation, cost of medication. Cost of consultation normally 10, 15 ringgit. I hope I'm right. This was an old figure. So if the law says that, you got to pay. But the cost of consultation or examination, 10, 15, 20 ringgit. What is expensive in MC? It is the cost of medicine. The medicine is the one that costs 60 ringgit, 70 ringgit. The cost of consultation is 10, 15, 20. So what it says here, Section 60F says that an employee, they are examined at the expense of the employer, meaning that you got to pay by a doctor appointed by you. So this is how you interpret. The reason I put in color so that you can see the difference. Right? When you read normally, you just say an employee. So now you say after examination, at the expense. That means you pay as a company and the doctor appointed by you. Right? So read it. Paternity leave, 7 consecutive days. Foreign male worker. So let's say a foreign male worker from Bangladesh or Nepal or Indonesia, if they, their wife delivered, they went back 9 months ago, now the wife delivered a child, he is also entitled to paternity leave. You cannot tell him, oh, you're a foreigner, tak dapat. Because all parts of all parts of Employment Act applies to local, foreign, permanent, and contract. So as long as they work 12 months and the wife delivers a child, they are entitled. So you cannot put in your policy, must work 2 years, must be confirmed. You can put whatever you want, confirm 2 years, whatever, etc. As long as they complete 12 months, the law says they're entitled. You cannot put any other conditions, right? So you can see there, as long as they work with you, not another company. That means when they join you, the clock starts, right? The clock ticking starts. So from the day they join you, 12 months, and after that, if the wife delivers, they are entitled for 7 days, 7 consecutive days. Weekend, public holiday, all are part of the 7 days. Now, scenario. So Adeline will help me to see what your answer is. Now, in scenario number 1, right, I won't be able to explain to you in detail, but remember, for the male employee, 5 confinement. For female, only for the first 5 living child. So now, in the first scenario, will the female employee qualify for maternity allowance? Yes or no? Will the female employee qualify for maternity allowance in scenario 1? No. Celine, you're correct. Why? Because this is her child number 6. What about the husband? Will the husband qualify for paternity leave? Yes, no, don't know? Okay, so yeah, because of time, the answer is also yes. Why? Because this is confinement number 5. So the husband is yes, the wife also yes. What about scenario number 2? Will the wife, the female employee, would she qualify for maternity allowance? Yes or no? Answer is yes, right? Because why? The child number 6 in this scenario adalah anak yang kelima yang masih hidup, right? The child number 6 is in fact the 5th living child. So maternity allowance, yes. What about paternity allowance? Will the husband qualify for paternity allowance? Also yes, because this is also a confinement number 5. So answer is yes and yes. Okay, so that's how you differentiate paternity and maternity. Now, section 60K, this is a section that has been the old section removed and put a new section. It says very simple. Any company, if you want to employ a foreign employee, you must get approval from Director General of the Labour Department. Now, if you don't get the permission, and if you're convicted, found guilty, a fine not more than 100,000 ringgit or a jail term, masuk jail not more than 5 years atau kedua-duanya sekali. So meaning that if you hire a foreign employee, you employ without permission, this. Now some of you all may say, yeah, we got to apply quota, go to immigration. Yes. What about those people that you employ without going to quota, without going to immigration? You hire the illegals. Can they fall in this category? So far, no case yet, but in my view, it might be in this category. So you not just the legal ones. Some companies, yes, when they're desperate for manpower, they just unquote whoever around, oh, you Bangladesh, masuk, right? That can also fall in this category. So the penalty is severe, 100,000 max or 5 years jail max or both. Flexi work arrangement. Now, this is interesting. Let me ask all of you all this. Anybody who can give me the answer that I want, I'm going to give you this book, right? So my colleague Yon will take down your details. We will courier this book to you, tomorrow or next week. So now, the first one to answer this gets this book. Who is your biggest competitor today? Adeline, let me know who's the first one. So my colleague is here. He's going to let me know. Who is your biggest competitor for manpower today? Who? The first correct answer, you get this book. Who is your biggest competitor for manpower today? You got to give me the answer that I want. No. No. Who is your biggest competitor for manpower today? Come on, Chuan Yuan. If the operator in a factory, he'll remain an operator, right? AI is not going to change his life, right? No. Quick, I need to give this away. No. No. Come on, you guys are not thinking. Yes. Linda, congratulations. This is for you. So please, my colleague Yon will get in touch with you. So let us know. Linda, what's the name again? Linda Charles. So give us your mailing address and your phone number. We'll courier this book to you. Yes, the biggest headache for you today is not the other factory, not the other company, the gig job. Now you must ask yourself this: why should I work for you for 1,700 ringgit, 6 days a week, 5 days a week, 8 hours a day, for a mere 2,500 or 3,000 ringgit? If I do the same amount of hours, same time, I do Grab, Food Panda, Lala Move, how much can I get? If I do 6 days work, 8 hours a day, I can get about 4,000-5,000 ringgit. So why should I come and work for you for your cheapskate 2,500? I'd rather do Grab. So the biggest competitor today is Grab, Food Panda, or shall I say, the gig economy. Because I can earn more there. Why I want to come and bersusah payah, kena maki hamun, cannot bring phone, cannot this, kena marah here, there, for 3,000 ringgit. I'd rather go do Grab or Lala Move or whatever. So the biggest competitor today is the gig world. So now, if you don't offer some form of flexibility, they will go. That's why today, it is difficult to hire, right? You're having difficulty to hire, you're having difficulty to retain, especially a blue collar, right? And you're cracking your head, how, etc. That's your fault because you don't know what you don't know. So now, the law says that employee may apply, right? Employee may apply for flexi work arrangement. They can modify their hours, days, and place. Now, you cannot say cannot because the law says they may apply, right? If you have a collective agreement, follow what is there. Now, again, Section 60Q says that the employee may apply, and within 60 days, when they apply, you must decide yes or no. If you decide no, you got to give them in writing. You got to tell them why. So tomorrow, if your blue-collar workers find out, kita boleh apply tau, flexi work. So 200 first apply, or maybe 10 first apply. Now you got to reply them individually because the law says whether you reject or not is up to you. You can approve, you can reject, no problem. But you have to give them in writing why you rejected. But my advice to you, don't go prepare another letter, A4 page, 80 gram, Arial font 11. There's a form in the forum, which is called Flexi Work Arrangement. Form, use the form. Make your life easy. So, but again here, employees may apply. So my advice to company, do your assessment, right? See what job. Like I said, you cannot be too rigid. This is no longer 1980s, year 2000, where people will work for you because there's no other options. Now with internet, with technology, right, with all this gig world, people can do any job. If I don't like you, I can just throw my letter at your face. I can Grab. Tomorrow I just open my app, I drive Grab. You pay me another month, Grab pays me every day. You pay me 3,000 ringgit, I slog for you like Hamba Abdi, I can do Grab, earn 5,000. The world has changed, but company's mindset, it is still 1970s. As though like you're the only employer in town. You're the only company in town that people must work for you. Times have changed, but we are still having the same mindset. So do your assessment. What job? Like operator. Today, operator is not easy to hire. If you have this rigid mechanism or rigid, concept, must work 6 days, must work 12 hours, forget about it. I'm sure none of y'all, anyone in this group, you are willing to work 12 hours a day or even 8 hours a day, 6 days a week. Anybody here willing to do work? I don't think anyone. You don't want, you can't, you don't want, but the operator can. So you are human being, they are what? Robots. No, human being. So one of the reasons why companies are not able to recruit as many as you want, not able to retain, is because of our 1970s mindset. So you have to offer some form of flexibility. So now, some of you all may have joined our webinar on flexi work arrangements. So I'm going to speed up this. Won't be able to go through, but do your assessment and then decide maybe flexi work, maybe shorter work week, part-time work, and so on and so forth. So think about it. These are some tips for you. I won't be able to go through because it's a lot. Now, there's a form that we have flexi work arrangement. Set your boundary, set an expiry date. Don't approve long-term, and always have it in writing, because the law also says that it has got to be in writing, right? So for those of you all who attended masterclass, I hope you've already implemented a policy. So for those of you all listening in for the first time, this sample policy is available in the forum, a very comprehensive 4-page policy. So download it. Maybe some elements are not relevant to you. That's okay. Remove it. Have it. Now, some of the important parts of the policy that you need to have. How do you make the application? What are the conditions for approval? How do you manage work performance? What is the employee's obligation? What is the superior's obligation? What about facilities? Now, all shock sendiri, shock, etc. Do you know, under the OSHA Act, right? Go and check it out. I hope I'm right. Company, employers must assess the workplace, even if it's their home, because they're working at home. OSHA says that any workplace must be assessed. So you are giving approval blindly, or boleh can work from, but what does OSHA say? And there's a penalty if you don't do it. So please go and check OSHA Act that says that any workplace must be assessed by the employer for safety purposes. So you all shock sendiri give workplace, flexi work, never read OSHA. Please go and read, right? Please go and read what does OSHA Act, the Occupational Safety and Health Act, says about working from home, the assessment, right? Don't shock sendiri give, etc. So please read. So this policy is available. Now, what if you are asked to come back to work? What if there's a business travel? What are those conditions, right? All this has got to be in a policy. So, and there's also a form. I didn't share the form here. So please go and download this. See whether, if you have one, good. Read ours, read the one that we have shared. See whether there's any areas for improvement and improvise yours. If you have something much better, please share a copy with us so we can share with the others. Okay, so so I'll skip this. This is for contractor for labor. Remember, if you don't follow what are the rules for contractor for labor, now the labor wants to inspect files, etc. It cannot. Remember, there's a fine just now. Now, this is for you. If you don't pay whatever that you owe the contractor, so that the contractor can pay the manpower supply. The manpower supplier, they supply you manpower. You're supposed to pay the manpower supplier so that the manpower supplier can pay those workers, but you don't pay. So this provision allows the manpower supplier, the contractor for labor, to bring you to the court to make you pay, right? And if you don't follow, the court says you got to pay, you don't follow, then be prepared to pay 50,000 ringgit maximum. And if you continue not to follow, the offense continues, maximum fine of 1,000 ringgit per day. Discrimination. Diskriminasi tak boleh, Section 69F. So now, discrimination, you may say, susah. Where can discrimination arise? When you approve work from home, two employees in the same job, let's say a HR clerk. Both are HR clerk, same job capacity, both got laptop, both job can be done. One you approve, one you don't approve. That could be a discrimination. I'm not saying that you must approve, but why did you approve one and why you didn't approve the other? Nothing to do with flexi work. So here there could be a discrimination. There could be. So now, if the employee files, complaints on discrimination, and after investigation by the labor director, and found that company is wrong, then again a fine of not more than 50,000. And if you continue it, maximum fine 1,000 per day. Now, again, I'm not saying that you must approve. I'm not saying that. But if there's a discrimination, other element discriminasi, then the fine not more than 50,000, but not more. And if you continue it, daily fine of not more than 1,000. So only if there's a discrimination in whatever that you do. And you're supposed to also put up posters on sexual harassment prevention, right? On awareness. This is simple. So if I come into your office, if I don't see notice in, somewhere on awareness on sexual harassment to raise awareness, a place I can see it, conspicuously means a place you can be seen easily. Again, maximum fine 50,000. Have you all put up the notice to create awareness? If you don't, do it. If you go to Facebook group, our Facebook forum, there are 12 sample posters. Sorry, I think 9 sample posters. Download it, print it, put it up. Or if you can create one, that's good, do it, put it up. Otherwise, 50,000 ringgit maximum fine. Those of you all, if you've been to our HR forum, you can see posters at the classroom area, you can see in the cafe area, etc. Why? It's part of the group, part of this ruling, part of this law. Forced labor. So another new element in the Employment Act is forced labor. What it says is, if an employee you threaten the workers, you deceive them, you force them, you don't allow them to leave your workplace, that is considered forced labor. If there's an element of forced labor, then there's a fine of not more than 100,000, that means not exceeding 100,000, or a jail term of 2 years, or kedua-duanya sekali, right? Maximum fine 100,000, maximum jail 2 years, or both. So remember this, forced labor is heavy, not just foreign workers. This can also happen to local employees. Now, the next one, night work, prohibition, all these are deleted. Remember those days, if female wants to work at night, you got to apply for night shift work, night shift permit. Now you don't need to, because larangan untuk kerja malam deleted. That means not relevant, not applicable anymore for women. Now, this is something extra. Sometimes what happens when you hire employees who need to do OT, during interview, you ask, OT boleh buat? Can you do OT? Yes, sir, 3 bags full. Boleh. After they report to work, they said, OT is my choice. You cannot force me. Now, those companies under RBA, sorry for you, OT you cannot force. But those who are not under RBA, as far as Malaysia law is concerned, if your employment contract says that they are required, they cannot later refuse. But today you have this issue because when you hire them, you ask them a question, can you do OT? Can. And then your contract says, if you work overtime, if. Okay lah, I don't want. You say if only what? I don't want. So you need to make sure that the clause is much more clearer, direct. For example, so if you go to the forum, download a sample employment contract that's got sample employment contract. There's a clause that we have mentioned there, so they give you some idea. You got to make it clear. In your contract, you must put there, this job requires you to perform OT from time to time as per company's arrangement. Failure to perform OT is a disciplinary, action can be taken, whatever, etc. So now, if you do that, then what this case of Kulit Craft says that if the worker, if it's a condition and the worker has acknowledged it, they cannot refuse it later, right? So this is an idea for you if you're having this issue. But of course, those companies under RBA, SMETA, Apple audit, social compliance, right? Those standards tells you cannot force OT. So this may not work for you, for those under RBA, Apple, and SMETA, and so on. These are some just additional info. Malaysia is also a signatory, right, for the ILO Convention on Forced Labor. So we have already, submitted the instrument. So Labor Department has also produced a guideline, Garis Panduan, about forced labor. So you can download it from Labor Department's website or go to Facebook. We have it there as well. Garis Panduan, or shall I say, guideline on prevention of forced labor. So Labor Department has also itemized 1 to 11. But of course, many of these are not in Employment Act per se, but the guideline is there. So have a look at it. And so general penalty, those days before the amendment, if anything happens, the maximum fine is 10. Now the maximum fine has gone up to 50. So for example, you don't give payslip, 50,000 maximum fine. Labor shows us, where's the contract? Don't have. Maximum fine 50,000, right? So these are the things. Who is an employer? Who is an employee? So let me just summarize this because there's 101C, part 1 and part 2. So what it says here, if you hire somebody, right? If you hire somebody and in the contract of service, right? It doesn't mention who are they, right? In the absence of contract of service, that means contract of service, tada. What it says, if you control their work, they got to apply annual leave. You control the work hours. He's only working for you, right? And whatever that he do is a very important part of your business. And whatever you pay him is, it's a major part of his income. And he's only doing it for you. He is an employee, you are employer, right? But in reverse, right? If none of it, in reverse, if, he is being controlled and whatnot, he's an employee. Let me give you another example. A cleaner in, let's say, KL, a lot of buildings, corporate towers. So a cleaner on Monday morning, she goes to company A, clean, finish. Then afternoon, go to company B, clean, finish. Then Tuesday, go to company C, clean, finish. Then on afternoon, go to company D. So every day, morning or afternoon, she's going to different office to clean. Now, is she being controlled? No. Is she only working for you? No. Whatever that you pay this cleaner, whether it's a he or a she, is this a major part of his income? No. The job that they do is an important part of your business, an integral part. You are in software development or in finance, but they're coming to clean office. So no. So no. The employee she's not an employee, you're not an employer. So that is the two difference, just to give you some ideas how to differentiate this. Okay, so these are no changes here. So I'm going to skip all this. Many of you might know it. So if you don't know, please ask in Facebook. This is all just extra info. I just have this there so that you have some, certain things to ask if you want to. Now, this is not the changes, but it has been there all the while. Why is off day, which is, for example, if your company works Mondays to Sunday, you work 5 days a week, Monday to Friday, Saturday you're not working, Sunday is rest day. Why off day, you need to pay 1.5 if they work OT? If anybody can answer me this, the second book is yours. The first answer, why is off day 1.5? Not 1.0. Why rest day 1.0, off day 1.5? The first answer. Okay, now, correct, because as far as, who's that? So, Yun? Okay, pay in, please give your contact details and your address to Yun. Yun will courier this book to you. You're right. So, because why? EA is designed, so let me explain next slide. So if you look at how EA is designed, Employment Act is designed for 6 days work. So Saturday is a working day, but you don't work. So you can have off, but the rate stays. So Saturday is still 1.5. And yep. So salary, I think you all know, the wages must be paid. If August, you must pay by 7th of September, right? But for rest day pay, public holiday pay, overtime, you can actually pay before the next month is over. Next wage period is over, you can pay. But the basic salary and your allowances must be paid by the 7th after your wage period. So if you pay calendar, for example, you pay from 1st to 30th. So you're paying calendar, 1st to 31st. Calendar, your salary must be 7th of September. But for rest day pay, public holiday pay, overtime pay, what Employment Act, even Sarawak, Sabah, same thing as well. You can pay before September wage period expires. That means the last date you can pay is 30th of September. Okay, so I leave all this. I think you all should know this. If you want to pay out annual leave and cash, you divide 26. ORP divide 26. All these are provided for in Employment Act. Now, deduction. These are not changes. I'm just giving you some extra info. I've covered most part of the changes. These are all some info. Now, you cannot deduct employee salary. If it's in green box, EPF, SOCSO, income tax, right, or any other written law says that you must deduct, you can deduct. You give an advance, you want to recover the advance, in the green box, allowed. In the orange box, the employee must request. For example, you have a union or you have registered a clubhouse, Club Sukan, right? All this can. Or if the company is giving shares, right? But in the red box, you cannot deduct anything. For the red box, you can only deduct employee requests and you get prior permission. So, for example, employee says, can you pay, I want you to pay my, every month, can you pay 1,000 ringgit to a party, right? Somebody. Employee must request, you must get labor approval before you can deduct and pay the third party. So what happens if employee damage your company property? Company give a car accident, or got summon, or damage the lift, or damage the computer, or damage something. Can you deduct from salary? Cannot, because it is not allowed under, in Section 24, do not give any provision for you to deduct for damages. You want them to pay, you got to charge them separately, not through salary. So if you are doing it through salary, you are wrong. If found, if this goes and found guilty, maximum fine 50,000 ringgit. So any deduction, green box, go ahead. Yellow box, orange box, the employee must request. The red box, you must get employee to request and prior permission from Labor Department. Okay, this is something shocking for some of you all, could be. Section 2021, now this has been there. Nothing to do with amendment. I'm just highlighting it to you, so at least you know. If the employee contract, some of you all enjoy contract, give contract, 1 year contract. Contract expire, or the employee resign, or you terminate them, you give notice. When should you pay the wages? It says that you must pay on the day the contract ends. So the contract expires today. Today is what? Today is 11. You got to pay today, not end of the month. Section 20 says so. Or if you terminate employee, you terminate them because of misconduct, you got to pay on the day, today. You terminate them today, you pay them today. But if the employee resign and don't give notice, right, you must pay them not later than the third day after the termination. Not today, but 3 days from today, you got to pay them. Not end of the month, not on the 7th. So please go and read again, Section 20, Section 21. Okay. Again, this is not amendment. I just want to cover. The law says that you can, those people who work more than 70% of normal hours, which is 45, they are full-time. Then 30 to 70% is part-time. The rest are casual. Casual workers are not employees. So sometimes we use the word part-time for the wrong method or wrong group. So those who come and go once in a while, etc., but work less than 13.5 hours, the right label is casual workers. Because part-time employees, they are covered under the Act. You got to pay EPF to them. You got to pay SOCSO. You got to give them annual leave. So part-time employees are those who work between 30 to 70% of full-time hours. So if you don't know, go and check this out. Sometimes we call the freelancers as part-timers. So those freelancers, etc., is best to call them casual workers. They come and work for a while, casual workers. But the moment if their work hour crosses 13.5, they are considered part-time employees, EPF, SOCSO, annual leave, sick leave, all this has got to be observed. Now, let me give you some ideas. There is a regulation called part-time, right? Part-time regulation 2012, if I'm not mistaken. So actually, or shall I say, you can leverage on part-time employment. Sometimes we are so rigid. Oh, no, everybody must work full-time. If you have an employee who's having kidney failure and he's going for dialysis, they go for dialysis 3 days a week. Typically, they do in the afternoon because after dialysis cannot work. So what they do, they apply annual leave, unpaid leave, sometimes MC, you do not. So to me, what you can do, you tell them, you know what, why not you convert yourself into part-time employment? So you come Mondays to Fridays, every day morning till 1 o'clock. Salary also, we give you half or maybe you negotiate a rate, win-win rate. So he goes easy for you. What about people who are going to retire? You don't need them full-time. You need them for a while, maybe half day, every day half day, or maybe 3 days a week. Allow them to convert to part-time. Or a female employee who delivered a child, she says that I don't want to work anymore, I want to stay at home. Why not you work part-time? You just come every day morning, half night, you come 9 o'clock, 1 o'clock, you go home, right? Or you come 2 days a week, 3 days a week. So at least you can still retain talent. So this is what I call as providing or creating a flexible workforce. Don't be so rigid. What you want is you want somebody to get the job done. Unless if the job requires full-time, then okay lah, cannot. But if you don't mind the people who are going to retire, you don't need them full-time. You don't need 100% of them. You just need them to work certain tasks. Or those kidney dialysis, patients, going through kidney dialysis treatment. So this is where it can be helpful to you. And this is an idea for some of you all, if you want to retain blue-collar workers, that is to pay mid-month. Some of you all might be familiar with this concept. So on the 15th or by the 15th, they've already earned the basic salary. Now, you must remember those people who are earning very low, even some of you all, if you're earning 4,000 ringgit, I can say once the salary is out, pay car, pay house, pay this, your money finish. Right? Kais pagi, makan pagi, you know, hand to mouth. So one of the method you can do is to break the basic salary into half. Half you pay on the 15th, because when I work from the 1st to 15th, I've already earned my basic salary. But you're only going to pay me end of the month. So what you can do, you can take portion of the basic salary by the 15th. So let's say by 15, if you are earning 1,007, you've already earned 850. So by the 15 or the 16, company will pay you 600 ringgit. Let's call it mid-month advance. And at the end of the month, I'll pay you the balance of your basic salary. I'll pay you all the overtime. Right? So this, I can tell you, might help in your retention of your blue collar or those people earning 4,000 ringgit. They will find it so helpful. You know, if they want to resign, they'll ask the other company. And because what I'm saying this because I have experienced it. I've spoken to, operators. Y'all cannot fight my level 1 because I can sit down and eat with them. I can put my hand on them. Of course, not female, male, etc. And they open up, right? So where I come from, they don't want to resign, or shall I say not many want to resign and go because they said the other company don't give mid-month. So mid-month is a big deal for some of them. If you're earning 8,000, 10,000, for you, no big deal. You get a lot of money. But for those people earning small money, less, the salary is low, they will find this helpful. This can help in your retention. I rather do this than keep on hiring and hiring and hiring, induction, hiring, give uniform, induction, hiring, non-stop. I rather do something to retain, to boost retention, than keep on hiring. Okay, so I'm done with my presentation. So I'm going to go for Q&A. But before I go, I just want to share with you a couple of trainings that is coming up. So for those of you all, if you are interested in certification, right? I've already shared just now the SHRM's global certification. For those who are, Bumiputra, you can apply for the YP funding. Open now. It's going to close soon. So if you want, please apply. Write into Sophie at Malaysia HR Forum, or you can contact us. But the best is write an email. So those who are under YP, you can apply for YP funding. Those who are not qualified under YP, you can apply for, ask your employer to sponsor you via HRDF. But we also have multiple internal certification within. So HR Forum does it. You have got, certified human resource analyst, certified payroll professional, certified TNA, certified HR business partner, certified com and ben, right, etc. So these are the various certifications that we have, which I would encourage all of you all to take up if you really want to move your level up to the next. And the masterclass is something that I do personally, not a cheap program, right? Expensive, yes, but the value that you get out of it. I've just shared a couple of things that we do, under this. So I would encourage all of you all, what you can do if you're interested to upskill yourself, you want to move to the next level, you want to learn the strategies, you want to learn the techniques, the tips, how to resolve, misconduct, from the time you issue a show cause letter, reply letter, etc., within 30 minutes. You take 2 weeks, 5 days. I take 30 minutes. How can I do in less than half an hour when you are doing it in 2 days or 5 days or 10 days, right? I use a form. How can I administer the separation process within 5 minutes? You all do calculation, what is the final pay, recalculation. I don't do any of those. Am I not compliant? I'm still compliant, right? You guys are so busy with paperwork. So this EAIR masterclass is to strengthen your EAIR knowledge, how to work efficiently, how to work effectively, how to retain people, how to manage people out, how to manage employees with medical conditions. So for those of you all, if you're interested, these are the dates. PJ, I think, is full house. You can try your luck, but I think it's full house. We're coming to Kuching, Penang, and Kota Kinabalu. So if you're interested, let us know. Okay, and last but not least, we have launched, together with our partner, we have launched TechStreet, Malaysia's first tech job portal. So if you are a company, if you're hiring IT jobs, you can, right now it's posting for until year end is free, right? If you have IT job, we've got IT candidates there. You can post your IT job for free, only IT job, right? That's why it's called tech jobs, right? Only IT jobs. So if you're interested, go to techstreet.co, not .com, techstreet.co, and create a company account and publish only IT jobs, right? Hiring IT is very difficult. So it's free until December. Give it a try. And this is a learning roadmap. So from the time you join HR until you become a HR director, what are the skill set? What are the competencies that you need to know, right? This just gives you some idea, so you know what are skills that you lack, what are the trainings that you got to do. So when you get the slides, check this particular page out. Okay, now before I go into Q&A, remember I told you I want to give you a couple of breakthrough. So I'm going to skip this because this will take some time to explain, but I hope you can join me in the masterclass so I can go through in detail. Now, today what you guys do, you are giving annual leave to employees. The law says 8 days, 12 days, 16 days. Sabah, Sarawak, Peninsula, EA, SLO, 8 days minimum, 12 days and 14 days. Sorry, 12 and 16 days. So, but some companies, they give more public holidays, 20 days for those people above 5 years. Now, when you do that, we think that, we are being good employer, best employer, etc. But the C employees, those who are C performer, they also enjoy. Why should they enjoy? Instead of giving the C performer, stay with your minimum 8, minimum 12, minimum 16, right? A performer, I give you extra 5 days next year. The following year, I'll see your next year's performance. So you give the extra leave based on performance. Medical leave. I'm sure most of you are listening here today, you're probably the good employees, the darlings, the angels. But the others are hantu. You take 3, 4, 5 days MC a year, they will take 14 days, 12 days, etc. They maximize it. So today, the A performer, the B performer, who are all the good ones, that you trust them, if they're sick, they're really sick. You insist they must give you MC. So they go to clinic, get MC, pay $60 or $80, but actually they don't need the medicine. But you want MC. So much so, all of us are mini pharmacy. We have a mini pharmacy at home, but we don't take the medicine. So when you do that, you are increasing your medical costs. What if I say, A performer, the first 5 days of your MC, you don't need MC. I trust you. B performer, the first 3 days in a year, no need MC. C and D, I need your MC, please. Right? So now you have achieved 2 objectives. One, you save medical costs. You reduce it, not save, you reduce medical costs. 2, you create an environment of trust. Your A performer, your B performer will say that the company trusts me. That trust is a very expensive item. Same goes to, team building. I'm not a fan of team building. I always tell people, team building, I'm a training provider, right? Training provider would want to make as much money from you, right? If any training provider listening today, you probably will get angry with me. But for me, team building could be a waste of money. Yeah, some people say, no, team building is good, depends how you do it. But end of the day, we have been doing team building every year. Have you seen a change in behavior? Have you seen a change in performance? Maybe 1 or 2, but majority no. The C performer, right? The C guys, right? All those cukup makan guys, last year C, the previous year C, this year C, CCC, I don't know what you guys want to see. The C performer, you go team building, I used to go team building, enjoy, have fun, banana boat, etc. Then Monday come back, MC first. Instead of spending so much of money on team building, why not you tell your A performer, ladies and gentlemen, if you're an A performer in 2026, company will give you, depending on what you can afford, 3,000 ringgit levy from our levy money is given to you. Go and do whatever program that you want. As long as within the context, you want to go and do a certification in project management, go, 3,000 ringgit, go. Top up a bit if you need to. B performer, 2,000. C and D, sorry lah. Now, this is how you can create breakthrough strategies. I can tell you this. The question is always, how do I give my people more? How can I give employees more without asking the boss extra money? This is how you do, right? So there are much more ideas. I won't have time because it's already 5:05. So I won't have much more time. But for those of you all, if you want to learn all of this, there are 26 strategies. You want to learn, please come to the masterclass. It is worth the money, right? If you don't have money, don't go team building. Tell the boss, no team building. I want to go to masterclass. Okay, so that's about it. And let me go for Q&A. Let my colleague, just give me a second to open up the Q&A. So those of you all, if you need to go, maybe you have some meeting planned, please go ahead. This video, right? Remember 2 things. 1, the slides will be shared in Facebook. You can download it. Second, the videos the recorded video will be in Facebook for the next 30 days. After 30 days, Facebook will remove it. You can also watch in our YouTube channel. So if you need to go, please go. If you're going to miss the Q&A, watch the recording once you have got time for the next 30 days in YouTube. So those of you all, if you need to go, please go. For the 2 employees just now, please give your name and contact details to Yun. We'll send you the book. And for the rest, stay tuned for a while. Let me cover a couple of questions. But those of you all, if you need to go, thank you for listening. I hope you have learned something new today. Maybe you're quite clear. You have got some new idea, etc. Fantastic. Please implement. Please follow all our webinars. Next week on Monday, we have another webinar on definition of wages. So I'll go quite deep into what is wages, the formulas, what does this section say, and so on. Today I covered 1 or 2, but I could not go deep because of time. Next week, I'll go deeper into wages. So for those of you all, if you want to know more on wages, come back next week. Okay, so those need to go, please go. Those who need to stay, let me continue some questions. Now, I won't be able to answer so many. There's a lot of questions, right? So let me just pick some of it. And those I think is unique, interesting. Let me find that. Okay, so could you explain further on the slide on OT? Off day is 1.5, all day. Yes, 1.5 all day. 1 hour, 1.5. 5 hours, also 1.5. 8 hours, also 1.5. Every hour is 1.5, right? It is not 1.0. 1.0 for the first 8 hours, that is for Sunday, for rest day. If your rest day is Sunday, if they work on Sunday, it's 1.0 for the first 8 hours. But for off day, whether it's Saturday or any other day, if it's off day, it is 1.5 for every hour. Okay? Now, Christy, company operating 5 days and they want to reduce to 4 days, subject to employee's consent. Is it legal to reduce salary by 20%? Answer is no. You can't. You cannot reduce the workday and reduce salary to 4. Cannot. So, Christy, I'm telling you, this is a disaster if you ever do that. Because not everybody can afford to live. For example, now, today, let's say you're paying me 5,000. Right? Literally, if you say 5,000 means 1 day means 1,000 lah. So 5 days, 5,000, for example. Now you're telling me that I'm going to reduce your workday to 4 hours, 4 days per week, but I'm going to cut your salary by 1,000 because you only work 4 days. I got to pay my house, my car, my kids, tuition, whatever. I can't. But, right, you can't. But if you want to do it, what you can do is this. You can make an offer to the employees. Say, dear ladies and gentlemen, dear employees, the company, have another concept where you only work 4 days, right? You can work minimum 4 days, but your salary will reduce to 4,000, right? It's going to be, proportionate. Now, those of you all, if you're interested, you can apply to company, make them apply, right? You cannot force them. You cannot say, you know what, Yun, next month you must come 4 days, no more 5 days, and I cut. Cannot. They apply. So there's no pressure, no force. They apply saying that, dear company, I would like to apply for the 4 days work week, and I do not mind my salary being reduced to 4K. So she applies in writing. You reply saying that, dear so-and-so, company agreed with your request, and starting next month, you only work Monday, Tuesday, Wednesday, Thursday. Your new arrangement is 4,000 ringgit. You create an agreement, an addendum. They sign, you sign, no problem. So if employee apply and you consent, no problem. But you cannot force. So Christy, this is one way to do, right? But the challenge, Christy, that I feel you might face is not everybody will agree to this. There will be some people who's excited. Maybe, for example, there is a female employee, husband is doing quite well, money is not an issue, or could be even a male, maybe family is quite rich, money no issue. He said, yeah, why not? It's okay, I don't mind taking 1K less, no problem. At least I work 4 days. But not everybody would agree to it. So if there's some people who don't agree, you cannot do anything. So that's one idea if you want to do it. So, but again, please think about it, whether it's worth doing it. Okay, Victor, I do have a situation where our company rents a house to use as staff hostel. Company is paying monthly rental for the staff to pay utilities. Can we get employee to sign consent? That means memberi kebenaran untuk menolak the cost of utility. That means the tenaga nasional water bill from their salary. Answer is no. You can't, right? You can't. But if you have applied for housing Act 446, Akta 446, and you apply for apply for Act 446, and you also apply to deduct from salary. So I think today you can deduct up to 150 ringgit. So if this is official house, approved under Act 446, you can apply to Labour Department to allow deduction up to 150 ringgit a month. So what you do, go and read Act 446, or you go to our Facebook. We have already put a recent posting. Recently, the Act has been amended to allow deduction. Previously it was 100, now if I'm not mistaken, 150. So apply for permission. If given, you can deduct. But you cannot deduct just like that, right? So please go and check out Akta 446, go to our Facebook group, type on hostel deduction, and talk to Labour Department to get their advice and do whatever necessary. If you're able to get approval, go ahead and deduct from salary. Maximum 150 ringgit. So Victor, please go and get this checked, right? Read Act 446. Okay, Serena, I got a question. I just joined this company since late 2023 or early 2024. The personal documents are all soft copy, no hard copies. Now, correct me if I'm wrong, we should have hard copies in file. Now, when Labour comes and audit you, right, they want to see hard copy. Your payslip must be hard copy. So if you want to keep in soft copy, you can, but when audited, you must be able to present a hard copy. But if you don't want to do that, you want to just keep all in soft copy, please fill up, I think Borang L, I just can't recall the forms, permission to keep your employee records in other format. Right? Kebenaran menyimpan daftar pekerja dalam bentuk, like when you say daftar pekerja, your employee records. So please check this out. Call Labour Department, get the advice. Okay, Selina, does it have to be first day off day and second day rest day? If a public holiday lies on off day, now what it says is this, now I've already covered in the slide, it's also provided for. What the X says is this: if there's more than one rest day, right? Maybe you got 2 rest day. For example, Saturday, Sunday, or maybe you have got 3, Thursday, Friday, Saturday, or whatever. The rest day, right? Maybe let me share the slides with you. Do you have the slides? No. Okay. So those of you all, if you have, your book, let me do a small exercise with you all. If you have your book, go to rest day, right? Let me show with you where's the rest day. Go to rest day provision. That is page 59. Let me share with you the exact clause. So go to page 59. Give me a minute. Okay, page 59. Look at 59 section 1. What it says, section 59.1. Selina, just take note of it. So go and search. It says that if there is more than one rest day, right, the last of those days shall be the rest day. So in other words, right, if you have for example, you got 3 days, 3 off days, that means 3 days they're not working. It doesn't matter, maybe Monday, Wednesday, Friday. Friday shall be the official rest day, right? So it's off day, rest day. So to answer your question, the last day shall be the rest day. If a public holiday falls on off day, no need to replace, because off day, it is also a working day. But you must replace the rest day. So if you read the public holiday provision, section 60D, it says that when a public holiday falls on a rest day, must be replaced. Off day, you don't need to replace, because off day is a normal day. That's why you also pay 1.5, not 1.0. Okay, and okay. So now payee lim. If employees are required to attend the team bonding activity on Sunday, should we grant them off in lieu? That means kind of like replacement leave for the attendance. So my take is this: if you make it mandatory for those people in the green box, mandatory, they must come, you got to pay OT. You got to pay them. But if you say it's optional, kalau you nak datang, you come. Don't want to come, don't come. And they come. But you make it a condition, right? Keep it black and white. Now, this is mandatory, all must come. If you want to make it mandatory, they must come, then you got to pay. But if you say this is optional, those who want to come, come. Those who don't want to come, don't come. So now if they come, don't need to pay. But make it clear, this is voluntary. If you come, there's no payment, no leave, nothing. So, but if you say it's mandatory, you got to pay, right? Get this checked. Okay, is it, okay now, Mazliana, is it mandatory for employee to provide panel clinic? No, right? If you don't want to provide, that's fine, right? You can tell the employee, you know what, you can go to GH, right? But the employee can ask you why you're not paying. That's why some companies, what they do, this is my personal view, you might want to get further advice. Some companies says you can go to GH, RM1. So can we terminate staff under probation but paid in lieu of notice? So now, the law, case law, not the law, case law says this, a probationer enjoys the same rights of a confirmed staff. So if you want to terminate a probationer, you can terminate him if he has committed a major misconduct. That means during probation, he stole money. He forged, submit false MC. You can terminate him. No need to wait for expiry. But if it's performance-related matters, he couldn't perform, inefficient, incompetent, you can only terminate when the probation ends. So when the probation ends, let's say, for example, probation 3 months, and he couldn't perform, not so capable, competency, etc., You tell this person, John, company is not going to confirm you because you cannot meet our expected performance level. So you have to pay him the notice period, right? You got to pay him the notice. But you cannot terminate earlier and so-called, you know what, I don't want you anymore. In the first month, I don't want you anymore. I'm going to pay notice. You cannot do that. So what does the case law say? You can only terminate a probationer if during probation, they've committed a major misconduct, forgery, right? Sexual harassment, for example. You don't need to wait for the probation to expire. After your due process, you might do a domestic inquiry, terminate, right? But if it's a performance-related issue, because you've already told them, dear so-and-so, the company is going to offer you this job, you're given 3 months to prove your capability. You gave 3 months. How can you terminate earlier? That's why the case law says that for probation purposes, you've already committed. Remember, your contract says what? Your probation period shall be 3 months. How can you end it earlier? You can't. But if the employer has committed a major misconduct, then yes. Okay, how about job requirement? Job requirement is the same, but salary decrease. Also cannot. You see, very simple. Cheng Cheng Ching. Okay, this is the Chinese, what they said, the festival. Okay. So now, Miss Cheng, or Mr. I can't recall, Mr. Miss. Okay, now see here. Now, you cannot reduce the salary. See, when both parties, the employee and the employer, when you come to a contract, there's a contract. So let's say now I'm the company, you are my staff. Now you and I, we have come to an agreement. The agreement is called employment contract. In the employment contract, it says that, Miss Cheng, you need to do this job. This is your job. You perform this job, I pay you 3,000 ringgit. You do this job, this is your JD, your KPI, your targets. You do this, I pay 3,000. The contract says so. Now, if you perform the job, I got to pay you, right? So you cannot. So if you perform the job, I got to pay you. Now, I cannot reduce your job, then I reduce salary, because contractually, I've already promised you that your salary is 3,000 and you do this. Now, if at all you ever want to do this, talk to the employee. Like there was a question just now, 5 days to 4 days. If you want to reduce the job, talk to the employee, dear Miss Cheng, the job that you're doing today is not so, no longer, the complexity is reduced, the workload is reduced. This job, we don't require 100% of your time. We would like to review a JD. Are you okay if we were to reduce your salary? So today you're earning 5,000 ringgit. Because of this, we only need you to come 4 days a week. Are you okay if we reduce 4,000? If she says, I'm okay, right? For me, I'll always get in writing, or it's okay, prepare the contract, make sure she agrees, document your negotiation, document all this, because tomorrow the person will turn around and say, I'm forced to, I'm whatever, etc. So document it, sign, she's okay, you're okay, done. So for those of you all, if you always ask, this, and now remember, in any relationship, employee, employer, supplier and client, or buyer and supplier, right? There's always a contract that has all the terms of engagement. So if anybody wants to reduce, so now in this case, right, Ms. Cheng, what you're saying is you want to revise the salary. Job and reduce, you want to revise. So you're going to modify, you want to modify the terms. No longer 5,000, but 4,000. If both parties agree to modify any terms, no problem. Right? Both parties must agree to modify, provided it's not against the law. For example, today your annual leave, minimum annual leave is, public holiday is 11. Now you said, because our business, can we reduce public holiday to 10? Cannot, because the law says minimum is 11. You cannot reduce to 10. So if any other terms that is not against the law, meet what the law says, for example, work hours or minimum salary, your basic salary, etc., cannot go below 1.7, that one no. But you want to reduce the day, like for example, can talk to employee, but you cannot force them. If employee disagree, no, you want, give me another job I can do. So you cannot force it. So okay, maybe one or two last question. It's already 5:20. Some of you all may need to go back. So if the employee has been working for OT yesterday and the past 3 days continuously, is there a rest day gap before the next shift work? Okay, now there's two ways to look at it. For those employees, first and foremost, if you read the work hour provision, hours of work, right, it says that an employee cannot be required to work more than 12 hours per day, right? See, one day has got 24 hours. For those people who are full-time employees, like you and I, our day starts at midnight. But for those shift workers, those night shift, morning shift, their day starts when they clock into work. You know, some companies, workers go in at 11 o'clock at night for night shift, or they go at 7 o'clock night. So for those people who start work at 7 o'clock night or 11 o'clock night, for them, their day will start 11 o'clock night until 11 o'clock the next day night, right? For them, 24 hours. So for you and I, because we are, morning office hour job, for us, normal shift, for us, our day starts at 12 midnight. For them, starts when they clock in. So for those, it doesn't matter whether they are shift workers or not, the maximum hours allowed is 12 hours. Unless there's an emergency, there's a fire, etc., they can exceed. But it cannot be every day. If let's say the company do poor manpower planning, that is not an emergency, right? There's a fire, there's a breakdown of machinery, you need them to come back, work longer, can, but not for poor manpower planning. Now, for those companies, now this could be shocking for many of you. For those company who is running 12-hour shift non-stop, that means the workers will be doing morning shift, night shift, after rotational shift. When you say it's a rest day, the rest day definition, if you look at Employment Act, the rest day definition for them, the shift workers who are on continuous shift, is 30 hours, 30, right? So where do you see it, right? It's 30. So now let me just give you if you go to section, let me just give me a second. So if you go to section 60A, right? If you go to section 60A, and let me see which provision was that. Shift work, sorry, not 69A. Shift work, give me a second. Okay, if you go, so the question just now, look at section 59, 1A. It says that in the case of employee engaged in shift work, the period of rest day, in order to constitute that as a rest day, it shall not be less than 30 hours. So please go and read up section 59, 1A. Okay, and last question. Sorry, I can't answer all because time is running. I'm sure you all need to go back as well. Okay, let me just take one from Swallow Purple. Swallow Purple, just swallow purple, don't swallow pills all. Okay, ad hoc public holiday declared by the government cannot be observed on that day. They want to give the replacement leave on another day. Now, remember this, Swallow Purple. Those people in the green box, you cannot replace, sorry, not just green box. If a public holiday, right? If the public holiday you want to replace, you must replace the public holiday to another day. You cannot change the public holiday to replacement leave. For example, tell an employee, okay, you know what? Hari Wesa, we don't want to observe. In the contract says Hari Wesa, we observe. No Wesa, but we give you 1 day annual leave. Employment Act do not have such provision. What Employment Act says that any non-compulsory like Wesa, Hari Raya, Chinese New Year, Deepawali, Christmas, this public holiday, Awal Muharram, these public holidays, if the company cannot observe on that same day, they can observe in any other day. That means you cannot change to replacement leave or annual leave. You must observe another day. So you cannot give replacement leave. So that is to answer question. Now, if you want to change the day, again, if you look at section 60D on employment on public holiday, it says that public holiday, if you want to change from one day to another, for example, Wesak, you don't want to observe on 1st June or Hari Raya, Awal Muharram, Deepawali, Raya, those non-mandatory, those mandatory holiday, which is King's birthday, the state Sultan or Yang Di Pertua, Hari Merdeka, Hari Malaysia, Labor Day. These 5 holidays for Peninsula. Sabah, you got another 2, and Sarawak, you got 1. So these 5 holidays, you must observe on the same day. If that is a Sunday or rest day, you observe the next day. You cannot tukar other days. But the non-mandatory holiday, if the employee and employer must agree to change to another day. So you must get employee to agree. So now the question is, do you need to get 100% agreement? In my view, answer is yes, because this is an one-to-one contract. Right? Employment Act did not say, okay, if majority agree, you jalan lah. No. Because when Employment Act is you and the employee. Contract is you and employee. So in this case, what you should do, you must get each and every employee to agree. Right? It's not about 50%. Now, if let's say now, for example, I'm the employee, you are the company. So now you said, okay, employee, if 50% agree, we change. I can go to labor now. I can tell labor, you know what? The company changed the holiday, never asked me, never discussed with me. I don't agree. How are we going to answer that? Okay. So, So remember this. When it comes to public holiday, number 1, if you are observing minimum, which is 11, Employment Act says that you must publish your public holiday calendar where people can see before the year starts. So that means 2026 calendar, you must have already published. Otherwise, maximum fine 50,000 ringgit. And if you want to change the public holiday to any other day, those non-mandatory holiday, by agreement between the employer and employee. So you cannot suka-suka tukar, the employee has got to agree. Okay, so I think that's all for today. Now, let's call it a day. So thank you so much for joining us. I hope that this webinar has been useful. And, I'm sure you've learned something. You may have discovered something new. Now, if there's something that I've mentioned which triggered you, I better check, please get it checked. Go and get, go and get some advice from Labour Department. I'm sure they're ever helpful as usual. Get some ideas from them. Is it true, not true? Are you in compliant? If you are good, not, get it changed. There's a saying, there's never a right time to make things right. So if you are doing something that is wrong, correct today. No point dragging it forward, right? And try not to play cheap stunts, cheap tricks, right? 5 days, 4 days, etc. To me, it's cheap trick. You have more to lose than to gain. So to me, if there's a contract, honor the contract, right? Both ways. You work, I pay you. If you don't work, I will take action against you, right? If I don't pay you, you can take action against me. You can go to labor, right? But if you work, I pay you. So honor the contract, right? If you say that, it's 6 days work, 5 days work, 5 days work. Now you cut to 4 days, want to reduce salary, cannot. Unless the employee agree, right? Because why? When you want to reduce any contract, you want to change anything, it's a contract. All these are bound by a contract. Any contract you want to change, negotiate with the other party, come to an agreement, write an addendum, sign, done. Nobody can say I'm forced, whatever, etc. Okay, so thanks a lot for joining us. So I hope that you have gained something useful today. So these slides will be shared in a short while in our Facebook group. Download it. The video will be available for next 30 days. Watch it if you need to, etc. And those of you all, if you want to learn more on wages, what is definition of wages, the various formulas, and what are the things that Employment Act talks about wages, transport allowance and travel allowance, are they the same? Not the same. Traveling allowance is not wages. Transport allowance is wages. You got to put it in ORP, right? Attendance allowance, ORP. Bonuses, contractual bonus is not wages. Performance-based bonus where everybody gets different sum, that is wages, right? Incentive plan, so all these I'll cover next week. So those of you, if you want to know more, please join us next week, Monday, 3 o'clock, similar method. And for those of you all, if you have listened to the webinar before, no problem. So see you next week for those of you all, if you want to come. Now, couple of reminders, see us at HR, see you at HR Tech, free conference, please come. And if you have any employees wants to do a diploma, please share with them the diplomas that we have. 7,999 to complete diploma, or you pay 399 per month, total 10,000, right? Online, fully on LMS, right? You don't need to come to class. You study anytime, anywhere. You can open up your LMS or your laptop at night or Sunday, Saturday is super flexible. For those of you all, if you have any employees of yours wanting to study, you want to make an impact in their life, this is a chance for you to make a change. So that's all. Thank you so much, and see you on Monday webinar.